Good afternoon and welcome to Employment Law 2009, 2010 and beyond. And thank you for joining us today. My name is Gina Hall and this presentation is the third in the PES Give Back monthly seminar series sponsored by Primary Executive Solutions. The webinar series is designed to help you better understand complicated legal and human resources issues and is always presented at no cost to you. So again, thank you for joining us. Our guest speaker today this afternoon is Attorney Todd Aidman from the Ford and Harrison Labor and Employment Attorneys. Guest speaker Aidman will discuss new laws that took effect in 2009, including changes to FMLA, the ADA, and the Lily Ledbetter Act. Today's program will also address other proposed employment laws that are making their way through Congress, as well as current trends. Again, thank you for joining us, and we hope you'll also join us for next month's webinar, which I'll be discussing at the conclusion of Todd's presentation. So without any further ado, Todd, take it away.
Well, good afternoon, everyone, and I very much appreciate you allowing me to give a presentation to you over the next hour or so. As Gina mentioned, I'm a partner with Ford and Harrison. We're one of the country's largest labor and employment defense firms, and we only represent employers in human resource type issues. What I'll be addressing today is some of the changes that took place in 2009 and what I see taking possible changes in 2010 and beyond. I'm going to make the following comment, and this is not meant as a political statement one way or the other, but just sort of a fact if you look historically. When Democrats control both the House as well as the executive branch, you're going to see a lot more employee-friendly laws. I tell a sort of joke to my clients that whenever a new law has the words free or fair in it, that normally means it's going to be neither free nor fair for an employer. There are going to be a lot of changes over the next year that I'm going to try to touch upon as much as I can in our short time together so you can know what's coming down the road. But the reality is, with high unemployment right now, in an economy in peril, and lots of new legislation out there, I don't think litigation is going to slow down. Matter of fact, I think it's going to continue to keep going. To back that up a little bit, I want to talk about a little bit what's going on in the litigation world. And this is without all of these new laws out there. When there are new laws, there are new ways to sue you as an employer, so you can imagine it's only going to compound the problem for employers. A couple of things that I want to point out that's going on with the current administration. Obviously, a great deal of equity is being spent on the health care debate. That will end eventually one way or the other. It will either end in favor of the administration or not in favor of the administration. Regardless of how it turns out, I think the administration is going to turn their attention to their domestic agenda in very short order. That's mostly been tabled right now because the healthcare debate's taken up so much time for everyone in the House. They don't have time to debate anything else in the Senate as well. But again, once that fight ends, however it turns out, I think you're going to see a lot more employee-friendly and labor union-friendly laws out there. Let's talk about a little bit what's going on right now so you have an idea of the problems. I'll tell you a pretty interesting story. I got a phone call from a client 2 weeks ago that's over in the Daytona Beach area. And this client had a Department of Labor investigator show up from the DeLand office of the Department of Labor. And I got on the phone with the Department of Labor investigator, and we were talking about what he was looking for. I then asked him, I'm surprised to hear that you're from the DeLand office. Candidly, I didn't even know that office was operational anymore. And he said with great cheer that the administration had taken stimulus money and hired and opened new offices for the Department of Labor. I jokingly respond to him that nothing says stimulus to the economy quite like a Department of Labor investigation. The administration's put a lot of funds, stimulus funds, into both the Equal Employment Opportunity Commission as well as the Department of Labor. What that means for you all as employers is you are going to see a lot more thorough and detailed investigations from both these agencies. I'm going to assume most of the folks on this line, on the phone line today, at some point in their life have received a charge of discrimination from the EEOC. Assuming I'm correct, then you probably know that requires you all to respond, and 9 out of 10 times the EEOC is going to come back eventually and find in your favor. The game's up for employers. The administration's putting a lot of money into the UC. They've hired, just in Tampa, for instance, I believe 7 new investigators. The investigators are being far more aggressive, spending a lot more time asking for on-site interviews, questioning employees, asking for requests for additional information. So they're really doing a more thorough and burdensome job in investigating claims of discrimination. The number of claims has also gone up dramatically. If you just look from 1997 to 2007, the number of charges of discrimination that were filed in the country ranged anywhere from 75,000 to 82,000. In 2008, 95,402 charges of discrimination were filed. That's 13,000 more than had ever been filed before. That number did not go down much in 2009. There were 93,277 charges filed. So what that tells you is employer, obviously, there is unemployment, and the high unemployment rate probably has a lot to do with that. But the other thing is the UC and again the Department of Labor is doing a very good job of marketing themselves to their customers, and their customers aren't employers. Their customers are folks who claim to be aggrieved. So it would be very, very important for you all as employers to make sure you keep an eye out for all the changes in the law and what's changed over the past year, because it's drastically changed the relationship you're going to have with your employees. There's a lot more ways for them to get you now, and it's only going to get worse. So let's go a little over some of the changes in 2009. I'm going to talk about some of the legislation which is past and present, including leave issues and pay issues. Obviously, with our short time together, I can't get into great detail about all of the FMLA changes. However, we've got, my firm has prepared a very good, what we call white paper on all of the changes to the Family Medical Leave Act. On my first slide, you'll see my email address. If you would like a copy of that, I'd be happy to send it to you free of charge. If you've got a pen handy, again, my email address is taidman, T-A-I-D-M-A-N, @fordharrison.com. And that's just backwards of the actor's name. And our website's fordharrison.com. If you'd like a copy of that very thorough, sort of Cliff Notes version of the changes to the Family Medical Leave Act, I'd be happy to send it to you free of charge. There have been some changes regarding pay. Also, the United States Supreme Court is making a number of decisions of late. The Supreme Court, of the 3 different branches of government, still, I would say, leans somewhat conservative. You probably could count it, there are 9 Supreme Court justices. 5 of them could arguably be considered conservative, 4 being liberal. And I don't mean those terms in a political sense. I mean those in the sense that the 4 liberals typically are going to side with the plaintiff or the employee, and 5 of them are typically going to side with the employer. That has not always been true. There was a decision last year that was a great shock to a lot of people about expanding one of the race discrimination laws that was a 7-2 determination. So I will tell you, even though the Supreme Court is somewhat barely dominated by conservatives, you're still going to see a lot of pro-employee decisions coming out of the United States Supreme Court, which then becomes the law of the land, and every court has to apply it.